Senator Audette, thank you very much.
Le peuple Anishinaabe. Merci d'accepter.
Thank you for allowing me to be on your territory every day when I warm my senator's moccasins. Now, before starting, I have a big surprise, something that made me cry. I didn't think that my beloved Stella would be here to support us. This affects your children and mine. You were there for the national inquiry, and you've supported me in S-2 since June. You're the one who provides me with support and nourishment every day. Thank you for your patience.
Sa patience.
I don't know where that patience comes from, but I'm going to try to speak with patience and with love today as I share with you my feelings about the injustice that far too many people are subject to. I speak today with I was supposed to say an unshakable sense of responsibility, but I'll just say with a strong conviction regarding my responsibility concerning this third reading of Bill S-2, an act to amend the Indian Act, new registration entitlements. The bill has now been strengthened and changed by the amendments made by the Senate. And I also want to say that it was our Senate that the government asked to look at the bill first, as Senator Ringuette so eloquently said. Thank you for having noted that important work. I believed in this work even when C-38 arrived in the last Parliament. Not the same government, although it is the same Liberal party in power. But S-2 arrived, and my message then was the same as it is now. We know that there are delays or deadlines that were set by the court, so in this case, the Court of British Columbia, but the issues have changed over time. And it makes sense that people who are impatient for justice and reparation be able to bring back that same message and to fight against all of the discrimination that flows from the Indian Act. I have a lot of love and respect for Mandy Gulmasti, the person and the minister, and that is unshakable. But as in a family with 5 children, it's rare to reach a consensus. We all have different emotional, intellectual, generational viewpoints, and we always try to have discussions with a lot of respect. The minister said very well this morning, you know, Michelle and I took 2 different paths. She said that with a great deal of diplomacy, and I really appreciated that. But in our discussions, out of respect, I told her, you know, the other place is an elected chamber. I have a lot of respect for that. But they are elected, and so the term has a beginning and an end. They are elected to carry out certain priorities of the government, and I respect that. But Canada has a particular form of democracy where we try to strike a balance, and we try to have a second look from the Senate, and in this case, it's actually a first look. I hope that my health will allow me to be here for a long time, to be able to change and amend legislation and vote on legislation that comes through this place. And I'd like to thank everyone who very bravely chose to speak on this issue, to relive these strong traumas, and to make suggestions even as they continued on their healing process. Because the things that they suggested in committee, in APA, really strengthened the bill. We heard from chiefs, former chiefs, experts, lawyers, even women who studied law and made it as far as the Federal Court of Canada, like Sharon McIver, who fought for 50 years. And before I get to the heart of Bill S-2, I'd like to say that we don't just exist in silos. We are all senators who have a great responsibility to each bill that we study. And I can't, detach myself from these bills. I'm only human. Maybe some of you might be able to, but I certainly can't. Sometimes things go quickly and we're not aware of all the details. But what I felt is that there is a growing discrepancy between the rights that Indigenous women have in our justice system and the rights that others have. This is something that I have seen and that I feel very strongly. It's something that we've seen together. We've been witnesses and sometimes even participants. And I know no one did anything out of malice, but sometimes there's a lack of understanding of the situation. Keeping people in ignorance is a very old doctrine. My goal is not to keep you in ignorance today, but, when we know something, it's important to share it. Yes, Bill 5 was passed very quickly, and so on and so forth, but I'd like to focus on a different bill that was passed. C5 will be another important debate. So I felt that there were two distinct constitutional systems, one of which came at the expense of the other. That's what I felt. So I'm trying to understand why the justice and political system in Canada clearly recognize second-generation citizens abroad and even have a system of gradual extinction since 1985, when the Indian Act was amended. That was changed without our consent, and so that rule about the second-generation cutoff was introduced without our consent. If you look at the text of C3, as it is now, not in its previous form, although it was the same, December 19th, 2023, the Court of Justice of Ontario said that the key provisions of the first-generation cutoff for people born abroad was unconstitutional. When I saw that, I thought, well, that's an argument in our favor, because you can't have two systems of justice. So this will surely help our cause. And yet the government, on their website, officially did not appeal the decision, because it was agreed that the bill had unacceptable consequences for Canadians whose children were born abroad. So we're talking about children being born here in Canada from Innu mothers, Mohawk mothers. Those people don't have those same rights. Tell me why. To me, I just can't accept that. Sometimes it makes me want to scream. We want to scream, but we don't. We hold back. So when we look at all the documents and the bills, we see the term lost Canadian. Now, a lost Canadian and their descendants are anyone who lost citizenship before that came into force. So we need to be able to show a substantive connection with Canada. So if there's one parent born abroad who was away for 1,095 days before the birth or the adoption, I mean, to me, it's very obvious. If you have one parent and you say yes, So do I have 45 minutes or do I have 15 minutes? 45? Okay.
Dans mon cœur à moi, là, dans le contexte où on
Now, I don't have the feeling that I am a lost Indian today, but this tells me that there are two distinct constitutional systems. So either you try to honor and celebrate identity, as Senator Coyle said so well about C3. Thank you. And I would like that we could also be able to celebrate and honor the identity of our, men and women who are Indigenous, and to celebrate that. So it's essential that we adopt Bill S-2 and the amendments proposed by the APA committee. And I'll tell you what those amendments are to refresh your memory. And I think it's important. So the bill would restore eligibility for status to individuals and their descendants who lost it due to emancipation. So that refers to a decision in the Nicholas case. It would also allow individuals to request to be removed from the Indian register. That was not in the Nicholas decision, but it was added into the bill. Then, the removal of outdated and offensive language, including the term mentally incapacitated Indians. That's good. But I'll say it again, that was not in the Nicholas decision. It would allow women who were automatically transferred to their husband's band to rejoin their original band. That's good. I think that should be restored. And the amendments that we studied and passed really sent an unequivocal message, very clear message. All the witnesses we heard from said clearly we need to act to eliminate all remaining forms of discrimination that flow from the Indian Act. It's essential to get rid of those provisions of non-liability. Now, the exclusion after the second generation cutoff has really destroyed families. From a strictly mathematical viewpoint, if you look how Indigenous Services Canada calculates things, there's a very complex calculation to lead to emancipation. And as Sharon McIver said so well this morning, when there are no more Indians, the land will be returned to the Crown. So that's a political issue as well. Unfortunately, that's not been said overtly, but I'm saying it. I've witnessed it, and I know. There was a national inquiry into missing and murdered Indigenous women, and we saw the evidence. I also want to underline the work of my colleagues. Senator Francis, thank you for your report.
APA, it was clear, very clear, that la loi sur les Indiens perpétue.
The Indian Act perpetuates assimilation. And the name of the Indian Act, the Gradual Emancipation Act of these savages, that is the same act now. It's just changed name. Now, I'm not a lost Indian. I'm also not a savage. And yet, this is the law that decides whether or not my child will be recognized as a status Indian. And that doesn't work for me. In the amendments that were proposed, there was the removal of residual gender-based inequities, repealing the provisions of non-liability, introducing a single-parent eligibility rule. So if one parent dies, and I can tell you, I was at Malutinam not that long ago, and I was with a mother, and I had to be with her, and she was so stressed, but I had to go along while the husband signed the paperwork. How is it that in 2025 that a woman can't be safe going to do this type of thing on her own? That's something else I don't accept. Fortunately, the person in question did sign the paperwork, but women should not have to go through that. They shouldn't have to come face to face with people who were violent to them or even simply absent. Another important amendment has to do with the 12-month implementation period.
Thank you. Thank you so much, Senator Tanis, for proposing this amendment. It is, and you have expertise. Which pair of shoe-clack shoes or moccasin you wear, you have expertise. And also with this APA committee. So he's proposing, he stated in committee, 12 months will provide some acknowledgement of Minister Galmasty's plea to complete the consultation. I agree with you, I agree with him, that the government should continue its consultation process. This consultation should be about how to support First Nation community to welcome new members. Very, very important. It was also mentioned the concern of fraud. We have that concern, and way beyond the Indian Act. But it's another subject, I would say, because it also affects universities when people apply for funding, and also for jobs or boards. We're looking for a First Nation, Métis, or Inuk. But when it's fraud, that's a subject very important to debate. So I agree. We're all concerned about fraud. Les témoins veulent éliminer l'exclusion.
The witnesses wanted to eliminate the second-generation cutoff. Everyone said that except for one Ganawage chief who didn't want to have Bill S-2 at all. And, yes, a nation, so one representative did oppose the bill as a whole. The national chief declared to the committee that while the Assembly of First Nations supported the fight against discrimination that Bill S-2 is intended to eliminate, it also believed that this bill constituted yet another example of just a piecemeal approach to dealing with discrimination, an approach that has never worked. She said it will never restore justice and will never provide lasting solutions, and added that the Assembly of First Nations endorses the amendments to the Indian Act that repeal the second-generation cutoff and introduce a system for granting Indian status to the direct descendants of a registered Indian or a person who is entitled to registration or who may be eligible for registration. Zoe.
Sharon McIver, when she says this morning that you are the today and tomorrow leader of what she's been doing for 50 years. And I will walk, many of us walk beside you. Thank you so much. L'exclusion, elle déclare pendant les témoignages.
In her testimony, she said that the second-generation cutoff has been devastating families for years. All of these consultations led to the conclusion that it was discriminatory. We don't need decades more worth of studies. We need to take action. Chief Barbara Cote, who represents 204 First Nations, in other words, 1/3 of the First Nations in Canada, said, ending second-generation exclusion and eliminating non-liability provisions are not controversial in our communities. This is urgent. We've been ready for a long time. Chief Vero Peul wrote, "These exclusion rules have broken our families and excluded our children. They jeopardize our language and culture. Patching them up is not enough. They must be eliminated entirely." Serge and I are the proof of this, because we actually expelled from the community and we don't hear the language every day. So, people have experienced the effects of this when they marry a non-Indian. Then, in terms of the non-liability provisions, for a long time, I heard from different governments that were in power, although there were different, it's still the same public service, the same department, just with different names. And they would always, always, always say, yes, Michelle, there's discrimination, but we're waiting for all of the trials to finish before the courts, and then we'll see what happens with that. And, I would think naively, oh, is that how it works with bills? No. But what was clear, every time, what I would be told is, if you want to challenge this, raise it with the chiefs. And I would say, look, I don't mind raising issues with the chief, but I'm talking about a federal policy, a federal law, which is obsolete, which was imposed on us. And now I have to go challenge my band council? No. So to me, it's important that things be put back in the right place. And let's not forget that it's only since 2008 that Indigenous women have been able to file complaints before the Human Rights Commission. 2007 or 2008. So there's not a lot of case law for us. We've been witnesses to this phenomenon, and I don't think that things should be slowed down at all. I think we need to move forward with Bill S-2 as amended and send it quickly to the other place. Senator Pate explained very well that there are sections that say that you can't complain if there's discrimination. And Sharon MacIver also said, if this happens with the charter, you can challenge it. So the Human Rights Commission often has difficulty when they're dealing with issues of Indian status and membership, because immediately the federal government will appeal and say, you don't have jurisdiction here. So again, that closes off doors in terms of where women or men can go to seek justice. So you can understand that for me, the courts aren't the only solution. And yet that's where we're sent. And there are a long list of people, families, dealing with the Indian Act, and particularly Section 6 of the Indian Act. So a long list of people. So if this bill were approved with amendments, a lot of these cases before the courts would end. And, taxpayer money funds the courts. There isn't any court challenge program anymore. Maybe it will come back. We'll see. So there's a whole series of legal challenges before the courts. And I'd like to reassure the minister when she says, I don't want to be dragged to court. But that's not what we're not taking her to court. We're taking Canada to court, federal government. And people have sometimes said, I don't want to be taken to court. Well, I think we could pass this bill, because then a lot of those cases will be withdrawn. Does it bother you to hear the phrase 40 years of consultations? It bothers me. I'm tired of repeating that. And we're talking about legal, political, academic consultations imposed by various inquiries and experts. It's just endless consultations that have been done. And every time they talked about the second generation cutoff and how harmful it is and how it's creating so much confusion and division within families. And the exploratory processes proposed by different governments since 2011, with Bill C-3 in 2011, that launched consultations. They called it an exploratory process, and I can tell you nothing's changed. Claudette Dumont-Smith, a woman I admire, was the special representative. In her report, she said there's no doubt that the most troubling inequity raised throughout this collaborative process was that of the second-generation exclusion rule. The Senate report, which was entitled Enough is Enough, you know, a Senate report is significant. There was testimony that was heard. The evidence was very clear. The conclusion was that Parliament, not the public, was dragging its feet. And even in the national inquiry, I was sure there would be a call to justice. 1.2.5 calls for the elimination of gender discrimination in the Indian Act. This is not optional. It's a legal imperative. This is a national commitment. There was a lot of debate around the duty to consult. It's clear to me that as an Indigenous woman, my nights cannot be negotiable. I can't believe that anyone would consider that. And yet, in the consultation, I fully understand the first Cree woman minister's desire to ensure that nations are able to welcome the people they want to welcome and to do the work they want to do. But not on C6.1 and 6.2. Because, again, this is just cobbling together or fixing small mistakes, when in fact the goal should be to honor these big principles which are enshrined in Section 35 about our Aboriginal and treaty rights. I've frequently heard the phrase nation to nation in this chamber.
A real honest relationship on something that it's crooked, not good, and unacceptable, this policy that we call Indian Act. We cannot build a nation to nation, an honest one. But if we do it on a modern treaty or a treaty or honoring the treaty already in place, that I will honor that every day. And the beauty also in the Section 35, we also know as women that all that section are guaranteed equally to men and women. So when Minister Galmasti will go in a nation to nation, we will make sure that, did you involve women? Did you involve youth? I'm sure you did, because it's written in the guidelines, federal guidelines on how we do consultation and accommodement. And we fought to have that. And court decision helped us to clarify, to make sure that we honor that. Vraiment important. Alors,
it's very important. So for me, the duty to consult decided in the Haida and Mikizu Cree decisions is very clear. It exists when there is an action that may affect Aboriginal treaty rights.
Maître Lafont at AFN was saying, Indian Act, citizenship, totally different. Indian Act, status Indian. We're not debating on citizenship. And for me, this is where the real debate of having a first-time ever Indigenous minister, it should be on that part. Nation to nation, citizenship, how we honor, how we celebrate, how we welcome them back, or how we connect with them. That is, for me, a real and honest consultation. Very honest. Alors, pourquoi ça me stresse?
So why am I stressed when we want to broaden the duty to consult in areas for which this was not conceived? For example, here, reforming discriminatory provisions of the Indian Act. when injustices recognized by the courts are remedied, Parliament has the duty, exercises its duty. And that's what I'm trying to do with conviction. I would like to wrap up on speaking about Nicholas versus Canada. Canada retained the inability to pass on status, even though it was recognized as a violation of Section 15 of the Charter. That is discrimination based on race or ethnic origin.
That agreed that they suffered historical disadvantage and the infringement was not justified. Et j'aimerais ça terminer.
I would like to wrap up by saying that among us, witnesses, people who have lived through this, and people who think of the next 7 generations, the social, psychosocial, physical, political, and all the other effects, as many people have named them, they do exist. We can't say that this had never happened. But I understand that the Senate had this duty for minority groups and for groups such as Indigenous women, Indigenous men. And when the opportunity opens up, there's a whole wave of people who will do something for today and for the next 7 generations, knowing that every government in the current context lives with uncertainty. There was recently a vote on the budget. The budget passed by 2 votes. We're not talking about a majority, not even we're talking about two votes that made the budget pass. So you can understand why we're concerned about giving responsibility to the first Indigenous who can do something. It's not that we're against her. It's that we're against the system and the political uncertainty that reigns right now. For that reason, I can't just rely on hope. We have a chance right now. We have duties. Let's act now. I don't think this is debatable. Today, to hear that she may not be here in the future, I don't know why people are saying, but while she's here, we need to support her. The discrimination has been proven, and we have the chance once and for all to fix the problem with Bill S-2. Thank you very much.
Senator Quinn, you have a question?
Yes, would the senator take a question?
Yeah.
Senator Quinn.
Thank you for the speech yesterday and today. This is to me, a very critical time in our history, in our relationship with First Nations. And the one thing that I question and worry about a little bit is we heard yesterday that, we'll have a year to have consultations, and you've indicated the budget just passed by 2 votes. But even in normal circumstances, having worked in Indian affairs, I worry that 1 year will fly by before anything is done. And the year will go by quickly. And the consultations will not have been done, or they will not have been done in a thorough, forthright manner. Is that something that would concern you? Despite the narrow margin of a budget, despite that we have a majority or a minority government, is that something that we should not be concerned about, given our history in discussions and trying to advance the democracies that surround our First Nations?
Sénatrice Audette.
Merci, Madame la Présidente. Je vais...
Thank you, Madam Speaker. I'll try to be as simple as possible in my answer. Whether the consultations last 6 years, 2 years, 2 weeks, whether various levels of government are involved, it's important to be present. But in this specific case, I cannot accept that consultations will be carried out on a question of discrimination. Our responsibility, whether the government has a majority or minority, the courts have said with Nicholas versus Canada, there is discrimination. We are not upholding the Charter of Rights and Freedoms. This is clear to me. That's why we need to go ahead with the amendments. With regard to consultations, how they should unfold, let's accelerate things. Let's accelerate First Nations claims, Indigenous claims. What are my rights? What is my role in the Canadian society? What does citizenship mean for an Indigenous person? That's what being autonomous means, not patching up 6.1 and 6.2. It's clear those two sections are discriminatory.
Oh,